The High Court has ordered East African Breweries Limited and Keroche Breweries not to advertise their brown bottle products until a case involving the use of the 500 ml Euro bottles is heard and determined. Keroche Breweries had sued the East Africa Breweries Limited, accusing them of patenting the brown bottles, yet it was a universal bottle. Mel Miendo has the latest front in the battle of the bottles.
The brown bottle was the topic of the exchanges in court as Keroche Breweries took on the East African Breweries Limited for alleged abuse of power and exploitation of market dominance. Through its lawyer, Senator Irungu Kangata, Keroche had filed what they called an urgent application to censure the directors of its competitor, EABL, over what it claims is an attempt by the brewer to restore monopoly in the industry. Appearing before High Court Judge Lady Justice Grace Nzioka, EABL, through its lawyer Kamau Karori, pushed back against the urgent application, saying it was also prejudicial as there was another case set for hearing on the 10th of March 2020.
I can assure you, as I'm expected to do my due diligence, I've already called out for that file. I'm expected to do my homework before I come here. We need to understand how are we handling this matter between today and 10th of March. And that takes me to the key question. What is it that is so urgent, okay, that we need to deal with? And two, should we deal with it in this matter or should it be dealt with in the other matter? That's where we start.
The vicious trade war started after EABL put up a paid advertisement warning legal action against anyone using its branded bottles to package other beers. In a rejoinder, Keroche accused EABL of using dirty tactics to stifle competition. Keroche's application lists the Kenya Breweries, East African Breweries, the Competition Authority of Kenya, Inspector General of Police and the Attorney General as respondents.
What his clients are doing is so devastating to this country that we need to be heard very urgently. It is a case of abuse of dominance, which in my case, I will illustrate, is a criminal offense, and our case is hinged on the idea of abuse of abuse of dominant power by a company which is all foreign, majority are international, is an international multinational company.
I'm still waiting to hear what is this that is so urgent that needs to be heard now. As my lady will understand, the question of engraving or embossing of bottles with the initials of the plaintiff is a matter that at a minimum started in 2017 when the other suit was filed. But in actual fact, as you'll see from the pleadings, it has been embossed since the year 2013. So there is nothing urgent about it. It's not a new matter.
In her ruling, Justice Nzioka ordered that no action be taken by the two parties, including posting of media advertisements on the subject until the court makes its ruling.
What is it that has triggered this application? An advertisement? Can we go there? And none of you is talking about it. I read my documents before coming here.
They were in the Daily Nation, and that's how it's put in the standard. Yes.
Full page.
Half page.
Yes.
I now know. So the status quo means no more advertisement.
Okay, that's fine.
Okay? If that advertisement has the effect of doing something, then we should stop the doing of that thing from today until we determine.
All parties are required to file their submissions and appear again before Justice Nzioka on Friday, 3rd January 2020 on the connection between the case in March and the present application. Mel Miendo, NTV.